Ethics changes at the Supreme Court. The justices have unveiled a new software that they say will help them identify recusals. But will it make a difference? I'm Zach Schonfeld, legal affairs reporter here at The Hill. And each week on the Gavel, we break down how the courts are impacting national politics and how politics are shaping the courts. And we've got a lot more to talk about than just ethics. Also today, Mark Zuckerberg on the stand at a trial in Los Angeles. We'll talk about this big case happening in California over social media companies and allegations that they have been causing addiction. Plus, a fight over what is arguably the biggest tunnel project right now in the United States. The Gateway Tunnel project that runs under the Hudson River into New York City, a big fight there between the Trump administration and New York. We'll break that all down. And joining me today is my partner in covering crime, Ella Lee, fellow legal affairs reporter at The Hill. We co-author the Gavel newsletter, which you can get in your inbox every Wednesday morning by signing up at thehill.com/newsletters. All right, Ella, every week we have so many cases to talk about. This week, let's start with the nation's highest court. Just this week, the justices announcing that they'll be starting to use a new software come March that they say will automate and help them identify recusals. Now, for lower judges, this would be nothing new. Lower judges have been using a similar automated system for about 2 decades now. But the Supreme Court does not have to follow that same code of conduct that all of these other lower federal judges do.
That's right. Lower courts have been governed by a code of conduct since 1973, but the Judicial Conference, which is what puts those rules in place, has no authority over the Supreme Court. So until 2023, the justices had nothing like that to abide by and basically govern themselves. The High Court operated on internal and non-binding consultations with the code used by the lower court judges, and then they also stuck with the general financial disclosure laws, but that led to sometimes inconsistent application of the law. And we saw a couple of scandals involving the justices sort of prompt them to adopt their own code of conduct. There was Justice Clarence Thomas, who was really mostly at the center of this firestorm. ProPublica reported that he failed to disclose travel and other financial ties with wealthy conservative donors. But then there were also justices like Justice Sonia Sotomayor, the court's most senior liberal justice, who the Associated Press reported had pushed colleges to purchase her books when she traveled to their schools, or not recusing from cases involving Penguin Random House, which published her books. And so Roberts initially just issued this signed statement on ethics and principles. It was signed by all 9 justices, but ultimately it just wasn't enough. People were calling for accountability. And so now they've got this ethics code, first time the Supreme Court ever had any official rules to abide by. And they're sort of taking that a step further now with this new software.
Yeah, this really, it's interesting to see how we get from starting with the scandals involving Clarence Thomas and luxury trips. And really, this new software directly follows that. It was in that statement of ethical principles when they released that about 2 years ago now, that said that they'd be looking into this system. To some extent, Ella, I'm still not sure how much of a difference it's going to make at the Supreme Court. There's been rumors that some of the justices may already be using some sort of automated system. Some of these justices served on lower courts as federal judges and used the automated software for lower judges. Did they start using that when they got up to the Supreme Court? Perhaps. We know that justices do often recuse. We do see it regularly as those petitions come in. But it's still, not always have the justices caught recusals. There have been issues at times. We've heard advocacy groups on both sides of the aisle at times taking aim at justices for not recusing. So it seems that that's the goal here, is to try to automate this, to try to ensure that there's nothing is being left behind, and that the justices truly are always going to recuse when they do so. And I also think it's important to point out that we saw this play out just a few weeks ago when Justice Samuel Alito, it was only just a few days before oral arguments in a big energy case, a battle between some local Louisiana jurisdictions and oil companies. And it was only until the last second before the oral arguments when Justice Samuel Alito announced that he would be recusing because of his stock holdings in the energy industry. And we've learned that is because when this case originally got to the Supreme Court, the company that makes the reason that why Justice Samuel Alito has a conflict with one of his stocks, its subsidiary had told the court that it was no longer going to be involved in the case, and so it wasn't going to be a problem. And it was only a few days before the oral arguments when Alito realized that wasn't the case and he actually needed to recuse. And just one example of what we've really seen playing out for months and years now of all of these cases. I think when people think about recusals, they sometimes think about the 60 or so cases that the Supreme Court actually hears arguments on a year. But the real problem in recusals is the 4,000-ish petitions that come in each and every year. There's just quite a sheer volume of these petitions that clerks have to go through. And it seems that up until this point, at least some of that process has been manual. It will now be automated. Litigants are now going to have to submit stock tickers of the companies involved in their cases so it can be run through that automated system, with the goal here that for the two justices who own direct stocks, Justice Samuel Alito and Chief Justice John Roberts, that they will be able to identify each and every time that they need to recuse. So we will see. Software starts in March, so looking forward to seeing it when it gets underway. But meanwhile, Ella, I know as we've been tracking this news at the Supreme Court, there's also been some big ethics development this past week in the lower courts. Tell us more.
Yeah, so a new advisory opinion from the Judicial Conference's Committee on Codes of Conduct, and that's that same conference that made the decision for the lower courts code of conduct. They gave judges new flexibility to speak out about the importance of the judiciary and defend their colleagues against attacks. Now, the opinion does not mention any specific attacks, nor does it mention the sort of tongue lashing that Trump and his allies have given judges when they rule against the president. But that context is hard to ignore, especially as the threats and attacks on the courts have surged. So the bigger updates here are that judges can now speak in defense of increased judicial security and funding without worrying about running afoul of the ethics code, which the committee said sort of falls under this umbrella of advocating for the rule of law and defending the independence of the courts. They can also stand up for their peers against unjust attacks. So the code allows judges to speak out against the persecution of judges and lawyers across the globe. But the committee's now saying that measured defense of judicial colleagues from unjust criticism and attacks also risk undermining judicial independence and the rule of law, even if that doesn't really rise to that level of persecution.
When this announcement came out, Ella, the thing that struck me is just thinking about, okay, what prompted this? The announcement, of course, doesn't specifically name Trump. It doesn't name any of the other specific comments and threats against the judiciary that we've seen in recent months. But you've got to wonder how much of just everything that's been going on over the last year or so, how much was that weighing on these judges' minds as they were in those meeting rooms of the judicial conference and decided to pass this new guidance, giving these judges more leeway. And I think, certainly these judges weren't living under a rock when they were drafting this and are taking note of what we've seen over the last year, because this is, something we've seen. Sometimes judges, they get a bit strong in their opinions. There's plenty of debates to be had about how far judges should be going in their opinions with their rhetorical flourishes. We saw that same debate just play out this week. There was a judge who quoted George Orwell's 1984, which caused a lot of firestorm among some legal observers who said that went too far and was just too much an opinion. But now these judges are going to, have some more leeway, it seems, to speak out. So it's going to be interesting to see which judges use this new policy to speak out more and how they do so. But meanwhile, in addition to judges, this is a policy that's going to apply to judges on the bench, but there's also been this dynamic playing out over the last year or so that you and I have been following about retired judges saying that they almost feel a need to speak out because they are recognizing the limitations that federal judges do have on the bench right now.
Yeah, I mean, look, because we have these sitting judges not able to say maybe as much as they would want to say, we've had some judges who are retired say that, I feel compelled to stand up and speak now in these judges' defense. And I mean, we talked about this last week. There was one federal judge who even resigned from the bench on that basis. Though, of course, now there's, sort of a question of whether there's more nuance to that departure. We've seen judges speak out publicly about their own experiences facing threats and attacks. We've seen judges speak out anonymously in news reports. And so this is an issue that's absolutely been brewing and I think is really top of mind for the judiciary right now.
Well, an interesting ethics update, a little bit hidden in some new guidance there in the fine print, but still pretty big deal here, pretty big change here for judges in what they are allowed to say. Okay, let's shift gears a little bit. Let's move across the country to California, to a big trial taking place this week that you've been following in Los Angeles. This is a case that involves social media companies and allegations surrounding addiction. This is an issue, of course, that has been talked about for years, but now it's actually playing out in the courts. And the trial has just begun, but it's already getting to huge moments here with today, Mark Zuckerberg, the CEO of Meta, set to take the stand in that courtroom in Los Angeles. It's a federal courthouse. Unfortunately, no cameras allowed inside. I wish we could put on the screen right now, the video live stream of Mark Zuckerberg testifying. But walk us through what you're watching for today and what you're looking for in this case as that testimony gets underway.
Yeah, so this is really a landmark trial over youth social media addiction. It's going to be the first time for Mark Zuckerberg that he's questioned in federal court about how Instagram, which is one of his companies under the Meta umbrella, affects the mental health of young users. And so the plaintiff in this case is a California woman. She started using Instagram as a 9 year old. She started using Google's YouTube as well as a 6 year old. And she claims that she became addicted and that the platforms are basically designed to addict kids like her, and that the apps fueled her depression and suicidal thoughts. So this case is a really big deal. Zuckerberg has testified before Congress before, but now he's facing a jury, which is weighing Meta's liability for harming kids who have used these apps. And so if the jury finds him liable, Meta may have to pay damages. Already, TikTok and Snap, which were originally named in this lawsuit, they settled for undisclosed sums before the trial began. So this is one that is going to be really closely watched, especially for the broader implications on the tech industry.
After today, I almost want to ask Mark Zuckerberg what he prefers. Does he prefer testifying in front of Congress or in front of a judge in a federal courtroom? Because I honestly am not sure his answer to that. And I don't know what my answer would be either, but I imagine that he does not enjoy either of those things. And then meanwhile, it's going to be a busy day all the way into the evening out in Los Angeles. We are expecting, of course, after this, the testimony wraps up today, there's going to be a press conference outside the courthouse. Some of the supporters of the child set to make remarks there, setting to bring this case out, of course, with no cameras in the courtroom, setting to make that case in the court of public opinion. So we'll be watching for that press conference this evening, too. And of course, whether Mark Zuckerberg is going to say anything to reporters as he exits the courthouse after leaving today. So we'll be watching for that. And now let's keep with our geographical tour here, coast to coast, talking about cases moving all across the country. We've talked about the big case in California. Now let's move to New York City, where a big lawsuit has been unfolding over the last week or two or so. And this is a fight that involves the Gateway Tunnel. This is a big project that will connect a new tunnel between New Jersey and New York City. For anyone who's ever taken Amtrak up on the Northeast Corridor into Penn Station, you know how congested that area is, and what this tunnel, how it's going to dramatically shift transit going into New York City. This multi-billion-dollar project, $16 billion in total. Some of that has been funded by the federal government until last fall, when the Trump administration told New Jersey and New York that they would be cutting off funding for the Gateway Tunnel project, as they conducted what they said was a review of those grants, as among all of the other grants that we've seen the Trump administration being looking at and cutting off. And then we saw in just the last few weeks that actually led work to being stopped on the Gateway Tunnel project and landed this fight in court when New Jersey and New York attorney generals, they went into court, said this was unlawful. They convinced a federal district judge that it was. Federal district judge said, Trump administration, you need to release the funds. Trump administration went to the appeals court. The appeals court declined to intervene, at least immediately. Then there has been, over the weekend, we were watching because there was a question of, is the Trump administration actually going to release the funds? New York was saying that it still wasn't out. And then that leads us all the way to this morning with a big development that I know you just got, Ella, before we sat down. Fill us in.
Yeah, that's right. The update this morning is New York Attorney General Letitia James announced that all previously funded frozen funding for the project has now been released. So she attributed that win to her lawsuit against the administration and said that the funds really should never have been withheld in the first place. And so as of now, it seems like Gateway is sort of back in action. But this was a nasty fight between Trump and New York's Democratic flank, including Senate Minority Leader Chuck Schumer, after Trump sort of called the project a boondoggle and said that the federal government was not going to be responsible for any of the costs being run up. Schumer accused the president of playing politics, suggested that cutting off the project would actually cause cost overruns, and not to mention really putting union workers out of their jobs. And so we heard similar remarks from New York Governor Kathy Hochul, who urged Trump to stop the insanity. That's a quote from her, and let the project's workers get back to work. So Trump has not weighed in since the funds were released, but it'll be interesting to see if this is a sort of choose your battles moment for him or not.
Yeah, and I took almost his post to almost be acknowledging that they were going to have to send this money out. I mean, he's saying, okay, we're not going to cover any cost overruns, but that's not what was at issue at this stage of the lawsuit. This was New York saying we need the reimbursement for some of the funds that we've already spent. It was about $200 million in total that they had been waiting on until just the last few days. So that says nothing about cost overruns. So I don't think what the president is saying there is necessarily contradicting or going against anything that's happened in this legal fight. And so, we'll see what happens there. I mean, obviously, government projects pretty prone to being overrun costs. Maybe not there yet, but we'll see as this project continues to go on. Now, the other thing in Trump's statement that caught my eye is he seems he's latching on to these news reports that have been coming out from several outlets that the Hill is not independently confirmed, but suggesting that Trump had actually threatened Senate Minority Leader Chuck Schumer, saying that if he did not name New York's Penn Station as well as Dulles Airport in Northern Virginia after the president, that he would not be releasing these funds. Now, the president is denying these reports. I'm just going to read you a little bit from his Truth Social post. He says this was, quote, brought up by certain politicians and construction heads, not me. It is just more fake news. So the president splashing cold water on those reports about the naming as a tit for tat there. But this question of naming things after Trump, and maybe it's the Gateway Tunnel or even Dulles Airport, those aren't the first times we've seen in this Trump administration talk come up of whether we should be naming some of our big national landmarks after the president.
That's right. This is a trend with the president. We've seen him try to rename the John F. Kennedy Center as the Donald J. Trump and John F. Kennedy Center. We've seen him try to rename the U.S. Institute of Peace as the Donald J. Trump U.S. Institute of Peace. And, you know, we've seen this sort of in other areas, trying to rename National Park Service cards or put his image rather on National Park Service cards. We've got these Trump cards and Trump programs. The president is wanting to put his name all over these things. And so in the Kennedy Center, I mean, there hasn't that former or current Congresswoman, Joyce Beatty, a Democrat ex officio board member for the center, she sued to block that takeover. We're seeing a lawsuit in the U.S. Institute of Peace as well. And right now, there really has not been much movement on those dockets. It's something that is sort of slugging its way through the court. And we're just going to have to sort of see what happens there. But this issue of Trump trying to sort of name institutions after him is something that is absolutely moving through the courts and something that will probably continue to move through the courts, even as we're seeing Trump sort of move forward with his plans regardless.
Or maybe we could even get into a Department of War situation where on the books in the law, it is still the Department of Defense. Department of War is not the legal name, but if you go to the Pentagon right now and look at the public signage and social media accounts, of course, you're going to see Department of War. So maybe that's how this will all end up. We'll see. Another update that I want to get your take on this week, and that is an update in the case of the man who is convicted of attempting to assassinate President Trump at his Florida golf course back before he retook the White House. Ryan Ruther, who had been sentenced just recently, and now he has begun his appeal.
Yeah, that's right. An attorney for Ruth this week filed a notice with the 11th Circuit Court of Appeals signaling that he's not only going to fight his conviction, but he's also going to be fighting the prison time that he was ordered to serve. So Ruth was sentenced to life in prison. It's the maximum sentence that he could face based on the charges that he was facing. And earlier this month, he was convicted on all 5 of those counts that he faced in connection with attempting to assassinate Trump. So at trial, he represented himself. And his attorney told me this week that that is one ground of potential error for the appeals court to review. The lawyer also told me that another area to be challenged is the conduct of the judge, Eileen Cannon, who was appointed to the bench by Trump, who in this case is the would-be victim. And she refused to recuse from the case, seeing that all the way through and ultimately handing down that sentence for Ruth. And so that plus the finding that Ruth committed an act of terrorism and other sort of trial errors may be challenged when this goes up to the appeals court. The life sentence was in line with the Justice Department Act 4. It matches the federal sentencing guidelines, but Ruth had sought sort of 27 years in prison, which would have been a downward departure from both of those requests.
Well, looking forward to asking you about it whenever the 11th Circuit does indeed make a ruling, whenever that may be. Now, I know for today we're about to run out of time, but before we go, let's talk about what you and I are each watching on our dockets this week. I'll start. I'm watching the Supreme Court this week. The justices are coming back to the bench on Friday for the start of their next session. And yes, there's going to be big arguments on guns and other things, and that is important. But of course, this is now also once again teeing up the question of, are we about to get the much awaited tariffs opinion? The court has announced that they expect to release opinions on this Friday, next Tuesday, and next Wednesday. So those are the next 3 days to watch. Those opinion drops will be at 10 a.m. Eastern time each morning. You and I will be covering those opinions as they come down, whether it's tariffs or anything else. And then you've got to wonder, the State of the Union is next Tuesday night, sandwiched right in the middle of those 2 opinion drops next Tuesday and Wednesday. And we saw last year when the justices went to the State of the Union at that time last year, they were sitting on a big emergency application involving foreign aid in the Trump administration. They ultimately ruled against Trump, and they interestingly released that ruling the next morning super early, 8:59 a.m. and raised a lot of questions as to whether that ruling was ready to go and whether they had just held on to it as they were sitting in the House chamber last year listening to the speech. So now you've got to wonder, is the State of the Union going to play an impact on the tariffs decision timing? I don't have an answer to that, but when you and I sit down next week for the show, I think we will get our answer. So, but that'll be one to watch. Meanwhile, I know there's a lot of action happening in the lower courts as well this week. What will you be watching for?
Yeah, so Tuesday, I'm going to be tuning into oral arguments before the DC Circuit over whether the Trump administration can dismantle the Consumer Financial Protection Bureau and move forward with mass layoffs that were planned there. So earlier, a three-judge panel had ruled that acting CFPB Director Russell Vogt could fire up to 90% of the agency's workforce. And that was because the lower court lacked jurisdiction to consider employment claims and there was no final agency action. But at the National Treasury Union Employee Union's request, the full federal appeals court now, not just a panel in Washington, agreed to review that smaller panel's decision and they vacated it. So this is looking like it's going to be the last stop on the road to the Supreme Court. And it's definitely going to be worth tuning into. And then Friday as well, we've got Washington Post and its reporter, Hannah Natson. They're headed to court to fight for the return of her devices that were seized during an FBI raid tied to a case involving one of her apparent sources. So that's another one that's going to be pretty interesting to see what happens.
All right, a lot of hearings to watch. Well, that does it for us this week. You can sign up for the Gavel, get it in your inbox every Wednesday morning by going to thehill.com/newsletters, where we will break down next week all of the analysis of whatever happens at the State of the Union between the president and the justices and everything else that is going to be unfolding in our nation's capital and courthouses across the country over the next week. But that does it for us this week, and we will see you next week on the Gavel.